So what we're going to be talking about today are the basics of estate planning. Feel free to put your questions in the comments or in the chat, and as I go through today, I will answer the questions. My goal is to give you a framework so that you have a much better understanding of estate planning and how it impacts you and your loved ones. As an estate planning lawyer at an elder law firm, we help people every day put an estate plan in place. And I can tell you, probably the best feedback we get is when you could just see the stress fall off of them. They feel so much better when they've actually addressed the question, the issue of estate planning. Because you know what? It's really easy to ignore. There's a lot of things you can ignore in life, and estate planning is one of them until you can't ignore it anymore. So what we're going to be talking about today is why you should probably bring estate planning and that subject to the forefront. Think about it, at least understand it more. So don't hesitate to ask me questions. I would love to answer your questions as we go through and I teach you about estate planning. So one of the things I want to say, it has to go with, well, who has an estate? You have to be rich to have an estate. No, everybody has an estate. You might not own a house, but whatever you have in your life is considered your estate, no matter how modest or how large. Folks that have a large estate typically do estate planning because they're trying to avoid having to pay unnecessary taxes. But folks that have a smaller amount of money may sometimes benefit more from having an estate plan because you keep your autonomy, your independence, and you keep the court out of your business, which is one of our goals, is to make sure that you will have the protections you need in place so that your voice will always be heard and that you have all the legal protections in place no matter what life may bring. So, do you have an estate plan? Some of you may already have gone to an attorney and had an estate plan drafted. Some of you may already have gone online and drafted your own estate plan. And some of you may have absolutely nothing at all in place. And I'm not going to ask what your situation is. But I will tell you that even if you think that you don't have an estate plan because you've done nothing, it comes as a surprise to people that the state has an estate plan for you. So even if you've done nothing, if you lose capacity or upon your death, and if you've done nothing to set up your own estate plan, the state has done so for you. And that might not be at all what you would want to have happen. We'll talk about what happens when you don't have the necessary estate planning documents in place. So let's go ahead and get started on that. There are basically 5 documents, which are the essential estate planning documents. Healthcare power of attorney, healthcare directive, also known as a living will, that's number 2. Number 3 is your durable power of attorney for finances. And number 4 is your will. And number 5 is some sort of trust. Now, is that an essential document, a revocable living trust or a asset protection trust? It depends on your situation. So whether a trust is something that's appropriate for you, we'll talk about. So let's go ahead and get started with the first document I mentioned, which is your health care power of attorney. First of all, what is it? That is a document where you designate somebody you trust to speak for you if you can't when it comes to your health care. So let's say you've been in a car accident and you are at the hospital, you can't speak for yourself. Who will? Your healthcare agent will. That's the person that you've designated under your healthcare power of attorney to speak for you. So it basically is a document where you grant authority to somebody to be your voice. The good thing about a healthcare power of attorney is if you think about it in advance, you designate somebody you trust, somebody who knows you, somebody who will be your voice, and you want them to be your voice, and they will speak for you because you can't speak for yourself. So what then happens if you haven't done this document? Well, you may have been in the situation where maybe you or a loved one haven't done any estate planning, you haven't done a healthcare power of attorney, yet the doctors will talk to you at the hospital. Why is that? They have to. So the state has a scheme, its own order of who can speak for somebody. So let's say you're married and you're at the hospital, the doctors will turn to your spouse and say, what should we do? Let's say you're single, you're at the hospital, you can't speak for yourself. The doctors will then turn to your children. And guess what? It's not your eldest. It's not any order. They'll talk to all of your children. And that might not be the best way to communicate what your wishes are. And that in itself, if you don't have a healthcare power of attorney where you've said, this is my agent, this is the person who's going to speak for me, and instead all your 5 children are being consulted about what your wishes are, you can imagine the stress that is being caused to them, the relationship issues that come up in that sort of situation. So one of the best things you can do for your loved ones, for your family, and for your own protection is put it in writing. Who is going to be your healthcare agent? Your healthcare power of attorney, which nominates your healthcare agent, will be what's called a durable healthcare power of attorney. Why is it durable? Because if you've lost capacity, you can't speak for yourself, the document must say it's durable. That way it stays in place and in effect, even if you are unconscious. So the number 1 document that we just talked about was your healthcare power of attorney. That nominates your healthcare agent to speak for you. Don't leave it to the state statutes and priorities to say who will speak for you, because that might not be who you want. Second document that goes right hand in hand with the healthcare power of attorney is what's called your healthcare directive. It's also known as an advance directive. It's also known as a living will. They all mean the same thing. What is it? It's where you put in writing what your wishes are if you are determined to be at end of life, and that no reasonable medical care is going to bring you back. So I didn't say that very well. For your health care directive, your living will to be in place, first of all, you've had to write it out, and it's a document you've already signed. Now you're at the hospital, you've had a car accident, and you are in a state such that not only can you not speak, but the doctors then put in writing that you are in a permanent, terminal, vegetative type condition with all reasonable medical probability. Nothing that they can do is going to make you any better. That's when the healthcare directive really comes into place. So you have a healthcare agent who's speaking for you, and now they've been told by the doctors, whatever treatment we're going to offer to mom, it's not going to make any difference. She is terminal at this point in time. Healthcare agent, what do you want us to do? Do we want to keep your mom on the apparatus that is keeping her body going, or do you want us to withdraw that life-sustaining treatment? I have to tell you that the decision to withdraw life-sustaining treatment is not an easy one to make. So the fact that you have put it in writing in a healthcare directive, a living will that says, I don't want heroic measures. If I'm at end of life, just let me go. Once the doctors are saying there's nothing they can do for me, then please let me go. Having that in writing very much helps alleviate stress and guilt that the person who's your healthcare agent is experiencing, because they're the one that has to say to the doctor, please stop all the medical treatment at this point in time. And again, that's not easy, and it makes it so much better for your healthcare agent if those are your wishes, that you put it in writing. I very much believe if it's important, put it in writing. By putting it in writing, you are making your wishes known very clearly. You're alleviating the stress that your healthcare agent probably is experiencing, which will be overwhelming. You're helping that person. And, in terms of, relationships and money, obviously a lot of people are concerned. They don't want to be a burden. They don't want to be kept alive if there's going to be no quality of life, and it's simply costing not just money, but a lot of hurt to the family who has seen that person in that state. 2 documents we've talked about so far: healthcare power of attorney that nominates your healthcare agent to speak for you, and your healthcare directive, advance directive, living will, which puts in writing what your wishes are should you be at end of life. The 3rd document that really makes a huge difference in making sure that you are protected and your money is protected is what we call a general durable power of attorney for finances. So this document is different than the first one I talked about, which was for healthcare. Your durable power of attorney for finances is the document where you grant authority to someone you trust and who knows how to manage money and to be in charge of your money if you can't be. So this is somebody who, maybe you're in very healthy and you're thinking to yourself, why is she talking about all of this stuff? I'm incapacitated, I'm in the hospital, I'm not healthy. That's what estate planning is all about, is planning for what might happen. And the best time to do it is to plan when you are in good health. You have your wits about you. There's no pressures coming in on you from, a bad diagnosis or other things. So paradoxically, it's the time when nobody even thinks about an estate plan, because why would you think about having an estate plan when you're perfectly healthy? But what is important, really important to do, and I'm an estate planner, I plan. I like to minimize risk and protect. And maybe you're that way too, maybe you're not. But one of the reasons you want to have these documents and what I've talked about, the powers of attorney, the healthcare directive, is that you want to make sure that in the event something bad does happen to you, you have designated who is speaking for you, not somebody else. So when it comes to your durable power of attorney for finances, you, for example, appoint maybe one of your children who, is really good with finances. You don't appoint the child who is really bad with finances and will not be a good steward of your money. This, number one, by designating the right person, will make sure that they carry out the job if you can't do it yourself. Number two, it makes it clear who's the decision maker and who's in charge of your finances. That really helps cut down on any confusion or strife, helps with family relations for sure. And when it comes to money, your money is being well managed. What happens if you haven't done your own estate plan, like we've been talking about, but instead allowed the state to put into place its estate plan for you because you didn't do so because you didn't think you would need it? If you don't have the legal documents that I've just described, the court will step in if you lose capacity, and you will become a ward of the state, which means you lose all your rights, and somebody else will be appointed as your guardian or your conservator. Who is that person? Well, it could be a family member, or it could be somebody you've never met before. You don't know because you didn't designate it. So you're leaving it to the court to say who should be in charge of you, your life, your health, your money. And whenever the court becomes involved in a guardianship, conservatorship, guardianships over the person, conservatorships over the money, what that means is everything is run through the court. Everything is in the court. And your financial plan, your personal care plan, your guardian has to report to the court. Lots of money is involved when everything in your life is being run through the court and given court approval, court orders. This is a situation that we can generally avoid with good powers of attorney. If you have a durable power of attorney, that's considered a less restrictive alternative than a guardianship. You won't be under a guardianship for the, I'll give you one exception in a minute. But if you don't have any of these documents and you lose capacity, yes, you will be under a court-ordered guardianship. I have to share with you one situation where the person did the responsible thing. They went to an attorney, they got their legal documents, they got their durable powers of attorney in place, and yet they ended up under a court-ordered guardianship. You know why? Because the person wanted his new wife and his son from a prior marriage to both be co-decision makers. Really bad idea. The new wife and the son couldn't agree on a thing. And when the gentleman lost capacity, they couldn't agree on anything. As a result, the documents failed because the decision makers could not agree, and it ended up in a court-ordered guardianship. So when I say it has to be a good power of attorney, whomever you're working with should talk with you about who is going to be your decision maker. And if you say, well, I want to have so-and-so and so-and-so, the attorney should talk with you about why might that be a bad idea. And you can bet I share that story about the new wife and the son and why that didn't work out so well and why we don't recommend co-guardians for the most part. So in the chat, there's a question. If someone signs a durable power of attorney for finances, does the person you have given permission to handle your finances do anything independently of you? Can they take control of your finances and do the things you don't want? That's a really good question. And that's one of the reasons people don't want to sign powers of attorney, is that they say, I don't want to give up my authority over my money. I don't want anybody managing my money but me. So my answer is, when you sign a durable power of attorney, as an elder law firm, we recommend that they take effect immediately, that they don't take effect later down the road when a doctor perhaps diagnoses you with Alzheimer's, perhaps not. The reason for that is what are called springing powers of attorney. Those that come into effect later are very, very difficult to work with. And if any of you have had that situation, you know what I'm talking about. So our clients, we counsel them. When you sign a durable power of attorney, it will be an immediately effective one. And you obviously have capacity. You can sign the document. So why are you giving authority right now to somebody to manage your finances? Because they aren't going to do anything unless you ask them to. They are not going to start acting independently without your knowledge or against your wishes. And if you say, well, I really don't trust that person, they might do it, then I say, well, then you've chosen the wrong person. Because the person you choose is the person who you've talked to and you've explained to them, you know what, I've named you under my durable power of attorney to speak for me, to handle my finances if I can't. Right now, I am capable. So no, you're not doing anything. And they go, of course I'm not. I understand my role is to step in and help you when you need help, not to do anything prior to that time. So when you're signing a durable power of attorney, you want to not only just say, oh, I know this person is very capable and they'll do it for me, but you talk to them too. You get their consent, and then you explain to them, either yourself or with the help of the attorney, that they're your job person who's been designated under the attorney in fact document. You're not doing anything right now. You'll only start acting when you need to. Having said that, do people violate their fiduciary duties and do things wrong, either because of ignorance or because of bad intent? Yeah, absolutely they do. But I can tell you that that person is far less likely to abuse the power of attorney when there's a lawyer involved. When does a situation happen when somebody misuses this power of attorney document? It's when they offload one from online, they print it out, and then they get mom to sign it, who may or may not have capacity to or understand what's going on. And then they take the document and then they go steal from mom. And yes, that's criminal. and they could be prosecuted for that. So we all know that vulnerable people can be defrauded, abused. That happens. What I would say as an elder law and estate planning attorney is to be aware, to pay attention, to make sure you don't put yourself in that place. And if you see anything that's going on that looks bad to you, we do have something called adult protective services. It can be anonymous. You give them a call and you say, I'm really worried about this because I'm seeing something happening with my neighbor or this or that doesn't seem right to me. So, as a village, we can try to protect each other. One other thing about financial powers of attorney, as an elder law firm, we frequently help people with long-term care and paying for long-term care. Often how we do that is through Medicaid applications. You might think, well, Medicare pays for my long-term care. It doesn't. It pays for your acute care and some rehab. Medicaid is the federal and state program which pays for long-term care in facilities and even at home. At Elder Law Group, we do a lot of Medicaid planning. There's a lot of misinformation out there and lack of information. Actually, people think that they need to become poor before they can go on Medicaid long-term care. That absolutely is not true for a married couple, not even for a single person. So our durable powers of attorney that we prepare for our clients will have language in it that allows the durable power of attorney to be used to help with Medicaid applications, because there's a lot of work that needs to be done at the time of a Medicaid application. Sometimes the powers of attorney just don't have the sufficient language in it. So people's hands are tied. We make sure that people's hands aren't tied so that if there is a strategy available to preserve assets and get quality care paid for by the state, then our clients will benefit from that. Do financial institutions always check first with the person who authored the durable power of attorney before allowing the person assigned the power over the finances to ensure that the actions are legal and true? No, financial institutions don't always do that. The law certainly doesn't require that, but for some financial institutions, they will do that. They're concerned that maybe this document is being misused. I did have, so what I tell my clients to do is once you've signed your durable power of attorney, take it to your bank, take it to your investment company, give them a copy of it and say, I want you to have this because I want you to be aware that I have a power of attorney and I've designated under that document that this person is going to be my financial attorney in fact. So we recommend that our clients be proactive so that in this situation, if the bank says, you've already given the bank the power of attorney, they already know that it's a valid document. They've already talked to the person who signed it. I mean, that's, best practices, right? What often happens and what I've seen before is somebody takes the power of attorney to the bank and the person who's authorized to act, they're called the attorney in fact or the agent. And then the bank says just that, well, I need to talk to your mom to make sure that this is okay. And the person says, well, mom has had a heart attack or a stroke and she can't come talk to you right now. So it's not that unusual to get that kind of question. And sometimes what we do as a law firm is we'll step in and explain that this document is enforceable. There is a state law that says that if we have to go to court to get the bank to accept this document, we recover our attorney's fees from the bank. Rarely does it have to get to that level. Usually we can, just talk with the legal department and they understand the situation, and then the power of attorney document will be accepted. But every financial institution has their own policies. Some of them will say, well, this is older than 5 years, I can't accept it. And it's like, no, there's no law that says that. That's your policy. And if we have to go get a court order, we will. Why would we go get a court order? It's because the person's lost capacity, and it's the only alternative other than going to a guardianship, which we're going to avoid. It's because of the financial institution's own policies that we make the recommendations that we do, that you take your durable power of attorney to them, give it to them, and let them know it's a good document. That if it has been more than 5 years, it's probably a good idea to review your estate plan anyway. And at that point in time, perhaps update your power of attorney so that it is not so stale that it's going to be a red flag to the financial institution. So a lot of this is kind of like a moving type target. So I'm probably getting away from all the basics, but and I apologize for that. But part of having a good estate plan is understanding how it works, and nobody's the durable power of attorney. All of those are what I call living documents. I call them living documents because they're in place while you are alive. In my opinion, these are the most important estate planning documents you can have, even more important than a will. And when people think about an estate plan, they think, well, I just need a will. That's all I need. I would say, if anything, you need these other 3 living documents much more so, because if something happens to you, you're incapacitated, all of these documents will keep you, your money, your family, your affairs out of the courthouse, and they'll be managed by somebody you trust. That's why I think they're so important. Let's move to the will. Number 4, the will. We all know what a will is. It's a legal document that says where your stuff goes when you die, who gets it, your family, charities, whomever you want to receive whatever is in your estate. And most people say, I just want a simple will. And I completely understand that. What people are really saying is, I just want to simplify my life. I don't want to make things more complicated than they need to be. I want to make sure that when I die, the people who get my stuff are the people who I want, and it goes to the right place, the right stuff, etc., without a lot of hassle. And most people will say, and I want to do it all without a probate. So this is where there's really a disconnect. People think if I have a will, I won't have a probate. Frankly, the opposite can be true. For a will to take effect, number one, the person has to die, and then for the will to act upon things, it has to go through a probate. A probate is a legal process where you file the will with a court, your executor is appointed, they're given letters testamentary, and then they act under your will and do what you told them to do. That's called a probate. And probates have a very bad name. And one of the reasons for that is if you've heard about a probate, it's because it was sensational in some way. It had a really bad outcome, and probates will happen with or without a will. Lots of times really bad probates are because there was no will, there's no guidance. And so the estate plan is trying to be implemented through a probate. What I would say is that when it comes to what's the right plan for you when you die? Is it going to be a will, or is it going to be a revocable living trust, which is an attempt to avoid probate, or something else? What is it going to be? I don't know how you can answer that question unless you talk to an estate planning lawyer, unless you're an estate planning attorney, because there's so much that goes into the analysis. So if you say, I just want a simple will, what you might actually be saying is, you know what, when I die, I want everything to be really easy. I want my house to go to my son, my bank account to go to my daughter, and that's all I want. I just want it that simple. So your will would say that, but as an estate planning law firm, we would set up your estate plan to avoid probate. Your house, we would do a transfer on death deed. Your bank account, pay on death. If you have life insurance or 401k or IRAs, a beneficiary designation. There are ways that you set up an estate plan to totally avoid probate. The will just is like a confirmation of what you said you wanted to happen, but it never has to go through probate because we set it up to pass without the necessity of probate. That's often what people mean when they say, I just want a simple will. So they're saying, I just want it easy. for my loved ones when I'm gone. A lot of times people will say, I've heard probate is really bad and I don't want a probate. So I just want a revocable living trust, and not even understanding what that means. So the fifth document I'm talking about is a revocable living trust, and that is intended to avoid probate. You create a document while you're alive. You put all your assets that you can into it, including your house, your bank accounts get retitled. You created the trust, so you're the grantor, you're in charge of it, you're the trustee, you benefit from it, you're the beneficiary. And when you die, let's say you want your house to go to one child and your bank account to the other. The trust can say that too. But in order to get there, you had to do a lot of upfront work while you were alive. You had to make sure that you put the house in the trust, the bank account in the trust, and then you had to manage it. You sold the house. Well, the new house has to be titled in the trust. You got a different account or investment, has to be titled in the trust. And it can work. It can work to avoid a probate. I'm just saying that there's a lot more maintenance and a lot more work in understanding how a trust works, because it's not intuitive. And oftentimes people, once they get a trust set up, they go, phew, I'm done. I never have to talk to the lawyer again. I get that. You should talk to the lawyer again, because trust requires work and maintenance once you've set it up. And if you did it yourself, or if you did it with a lawyer that doesn't take the time to really help you understand things, you might not have realized that your IRA can't be in your revocable living trust. And so you must make sure your beneficiary designation on it is right. There's retirement assets in particular are not titled in the name of a revocable living trust, so the trust doesn't govern them. So there's more understanding, I think, that's required when it comes to revocable living trusts. I mentioned earlier that we do elder law, we do Medicaid planning, and one of the things that I personally don't like about revocable living trusts is that if my client is a couple, and if they are concerned, they don't want their spouse to become poor once they've died, husband dies, wants to make sure provides for wife, for example. If they have a revocable living trust, there's no way to protect assets for her against long-term care costs. That's what our state law says. In Washington state, to protect money for the spouse that you've left behind, you have to do it through a will. You have to have a will that includes within it a special kind of trust. It's a discretionary trust that's made in the will that comes into being when the person has died, and it has to be created through the probate process. So the probate, let's say the couple has, $1 million estate, $500,000 house and $500,000 in the bank account. When the first spouse dies, we'll protect that deceased spouse's 50% of the estate, or $500,000. It will go through the will, through the probate, into a trust for the surviving spouse. That money is always protected from taxes, from creditors, from Medicaid counting it as belonging to the surviving spouse. So if they ever need long-term care, they don't have to spend that money down. In the situation, let's say husband dies, they put $500,000 into the trust through his will, through the probate for the surviving spouse. $500,000 is in the trust. The wife, who's the surviving spouse, has $500,000 house. She qualifies for Medicaid, no spend down. If she needs Medicaid or long-term, if she needs long-term care, Medicaid will pay for it with that configuration of assets. So when people say, well, I want to protect assets for my spouse, but I want it really simple, we have to have a conversation about, well, here's what the options are. If you really want to protect money for your spouse, you might have to do it through a will that has an asset protection trust in it, and that will go through a probate. So those are basics, the 5 basic estate planning documents. And I hope I was able to convey as we went through this, just, the clarity of having these documents and understanding the plan, how they will help relieve stress, preserve relationships, certainly protect money. You can protect a lot of money, not just from long-term care costs or from the court, but from taxes as well. We didn't really get into taxes too much. That's also always a part of estate planning when folks are over the $2 million mark as well. All right, let me see what's in the chat here. Is there a minimum amount of money needed to create a trust? No, there is no minimum. The question would then be is what's the utility? Why would you, the law doesn't say there needs to be a minimum amount, but from a common sense perspective, why would you create a trust unless you are trying to protect something? So that's a kind of a hard question to answer. Maybe if the person wants to stay after we go off the live event, we can talk in a little bit more detail, with the caveat, this is an educational presentation. I cannot give legal advice in a public forum. All right. In a revocable living trust, as a married couple, should the bank accounts, annuities, life insurance policies become part of the trust as a primary beneficiary or as a secondary beneficiary? That's a really specific question. I really can't answer unless I knew more of the context with it. So again, I apologize. I do my best to answer all the questions, but I can't answer them all without a little bit more information. So, all right. Well, we're just beyond 1240. So if there are any other questions, put them in the chat or comments and I'll answer them while we're doing the live recording. If not, I am Lynn St. Louis and I am with ELG Estate Planning. You can find me and the rest of our legal team at Elder Law Group, which our website is elgwa.com. Our phone number is 509-468-0551. And it was a pleasure sharing time with you this afternoon. And so we're going to go ahead and sign off now from the live stream. If you want to stick with us, happy to answer questions for those who are still with Zoom. If you just want to unmute, I'll answer your questions.
So there is a question in the chat that popped up.
Yes, good question.
From Kendra.
All of that is the executor different from durable power of attorney for finances? How do those roles differ? Yes, they are different. So the executor is the person who carries out your wishes under your will. So you've died. So they are the executor of your will. They're your personal representative. They are appointed by the court and they're given letters testamentary. Their job is to carry out your will. Whereas the person under your durable power of attorney for finances, you are still alive, but you're probably incapacitated if somebody else is managing your finances. So they are acting in your best interests as you would if you could while you are alive. There's similar roles in that they deal with finances and business, but they're at different times. The attorney, in fact, under a durable power of attorney is acting while you are alive. Your executor acts when you are deceased under your will. And what really surprises and causes a lot of people upset is between the time, let's say that your attorney, in fact, they're managing everything for you, then you die, and then they want to keep managing everything for you, but they can't, because until they've been given authority by the court, because your will has been filed with the court and it will be probated now, and they get their official stamp that they have authority, which is the letters testamentary, there's this gap when nobody can act. And that's the time you'll definitely want to see an attorney to help you get through that time frame. Yes, we are licensed in Washington and licensed in Idaho. Okay, those are all the questions I see. Thanks, everybody. It was a pleasure.